What is a trademark and how is it different than a copyright or a patent? I'm Angela Langlotz, trademark and copyright attorney. I go live here on weekdays to answer your trademark and copyright law questions. So if you have questions, drop them into the comments below. I'll answer them on a future live video. So a lot of people want to know what makes trademarks different from copyrights or patents. Well, a trademark protects your exclusive right to use a distinctive word, phrase, or other symbol in conjunction with the goods and services that you sell or offer in the marketplace. So if you want the exclusive right to use that word or phrase or symbol, then you should register a copyright with the United States Patent and Trademark Office. Now, two types of trademarks are possible. One is called a common law trademark, and the other is called a registered trademark. A common law trademark is a trademark. They're trademark rights that you have because you've been using the mark in commerce, and people know that you sell these goods or services in a certain particular area. That area could be your local city or county, or it could be nationwide. You get the rights to that trademark by using it to sell your goods and services in commerce. That is a common law trademark, and it is restricted to the area in which you're actually using the trademark. A registered trademark is one that is registered with the United States Patent and Trademark Office, and the trademark registration gives you legal rights to protect that brand anywhere in the United States, or any of the US territories. So that would include places like Guam, the Virgin Islands, the Marianas, Puerto Rico, any US states and territories. When you register, you get protection in all of those states and territories, even if you're not yet using it in all of those states or territories. So in that sense, a registered trademark gives you much broader rights than you might otherwise get with a common law trademark, because as soon as you apply, or as soon as you get the registration, rather, you are protected in every state in the Union and in all US territories from other subsequent users of that trademark. Now, your trademark registration doesn't just protect your trademark that's listed on the trademark registration. It also protects any confusingly similar words or phrases that are used in conjunction with the goods or services that are listed on your trademark registration certificate. It also gives you broader protection in that it's not just the goods and services listed on the trademark registration certificate that are protected. It's those goods and services plus any so-called related goods or services. What's related? Well, it really depends on what your goods and services are. That's a topic for another video. A trademark registration is important because it protects your right, your exclusive right, to use that word or symbol or phrase in conjunction with your goods and services or any related goods and services. And that trademark right, as I said, extends to any US state or territory. And it also means that the Trademark Office, the United States Patent and Trademark Office, will refuse to register any confusingly similar trademarks that other people might apply for. So if someone applies to register something that is confusingly similar to your trademark or conflicts with your trademark application that's already been submitted, the Trademark Office will either put that application on hold or it will refuse it altogether if your trademark registration has already issued. So in that sense, a trademark registration gives you the right to sort of have the Trademark Office serve as your trademark watchdog, watching out for any trademarks that are applied for subsequent to yours that might be confusingly similar and refusing those. Copyright, on the other hand, protects your right to your own creative works that you have actually reduced to a tangible medium of expression. That's the term that we use in copyright land. So it doesn't protect the idea of the work. It protects the actual physical manifestation of the work. So you had an idea and you decided to create a piece of art. You had an idea and you decided to write a poem. You had an idea and you decided to create a screenplay. The reduction of that idea to a tangible medium, you wrote it out, you painted a painting, you wrote out the poem, you created the architectural plans. That physical thing is what copyright protects, not the idea of the physical thing, but the actual physical thing. You can register that with the Copyright Office. Now, you get prevention, not really prevention, but you get the right to prevent others from copying your creative work as soon as you've reduced it to a tangible medium of expression. The problem is that you can't get into court to sue for the infringement of that copyright unless the copyright is registered with the United States Copyright Office. So when you register, you get the right to ask for statutory damages for any infringement. That's the right to just say, hey, you copied, here's your bill. You have to pay me. If you don't register for a time and then you register, for example, after the infringement has occurred because you want to get into court to sue for copyright infringement, then you're limited to your actual damages and you have to prove those damages in court. You can also force the infringer to disgorge any of the profits that they made from their naughty infringement. But again, you have to prove all that in court. So a copyright registration basically gives you the right to say, hey, here are my damages and pay me. It's kind of like a speeding ticket. We don't have to ask whether or not you copied. We just say, okay, it looks like you copied. Here's your ticket. Patents protect your exclusive right to any new and non-obvious, useful, mostly, or decorative invention. So we think of patents as mostly protecting useful things, but there are certain patents called design patents that can also protect certain decorative or design elements. I'm not going to spend a lot of time talking about those here. When we think about patents, we generally think about what we call utility patents. That's protection for a useful idea that maybe we haven't even reduced to an invention yet, and we don't have to. We can still apply to register for patent protection, even if it's just an idea. So the three types of intellectual property have a little bit of overlap, and that's why many people get confused. For example, you can register both a copyright and a trademark for logos. Logos are creative, so they can be registered as a copyright, as a drawing or anything like that. That can be registered and protected with a copyright. They can also be registered with the Trademark Office. Design patents are a thing, but we can also register that creative thing, if it's sufficiently creative, with the Copyright Office. And we can also register a creative shape, for example, as a trademark. So there is a little bit of overlap between the three types of intellectual property, but I hope I explained it well so you get a general concept of the delineation between the three different parts. I'm Angela Langlotz. I go live here on weekdays. If you like these videos, hit the subscribe button and give me a like. And if you have any questions, drop them into the comments below. I'll answer them on a future live video.